Okay, this is the 2021 new law update. The 2021 case law update will be provided toward the end of October, the 1st of November. And the two updates combined constitute the training outline of the Maine Criminal Justice Academy for recertification training in law updates for the year 2001. This new law update is list out summaries of laws relevant to law enforcement officers from the 130th Maine Legislature, the first regular session and the first special session. I think there's only one summary from the first regular session and the remainder are from the first special session. So with that, this is dated October 13th, 2021. The summaries were prepared by yours truly, Brian MacMaster from the Attorney General's office, with reviews and edits by Laura Yustak from the Criminal Division of the Attorney General's office. There were 1,741 LDs that were introduced into the legislature. 486 of those resulted in adoption in some fashion and became chaptered laws. None of those new or amended laws are reflected yet in the online statutes that should be soon. So be aware of that. The vertical criminal statute publication is out, as well as the vertical motor vehicle code publication. So these new or amended laws are reflected in 17A and 29A. But you won't necessarily be able to look at the new or amended laws online in terms of the statutes until they're updated. So keep that in mind. We've summarized about 50 of the new chaptered laws and some significant juvenile code changes that we'll go over. As I go through this, we may skip over some or part of a summary. Some are fairly obvious, and some are more of a direct interest to prosecutors and law enforcement officers. So with that, note on page 2 of the update, there's a link to the actual LDs right here. But those LDs, for the most part, are not what ended up as chaptered laws in the end. As you know, it goes through a process in the legislature, and we end up with the chaptered law. There's also links to the chaptered laws. The first regular session link are chaptered laws 1 through 41. And again, I believe there's only one in this summary that came from the first regular session. And then chapters 41 through 486 came from the first special session. And there's the link right there in the update. If you have any questions, suggestions, or other comments, feel free to contact me at that contact information that you see there on the screen. And with that, we're going to go to page 3 of the 2021 new law update. And these are categorized, the first being the changes in crimes and criminal code. And again, I may skip over some of these, but there are quite a few, and it will take us a little while to get through it, but let's give it a try. So the first one we're looking at there is an act to give special weight to discriminatory motive in sentencing for false public alarm or report. And that's sort of self-evident, as is explained there. It permits consideration at sentencing of any discriminatory motive of the person making a false public alarm or report, and convicted of that in terms of sentencing. The court can weigh the discriminatory motive in terms of the sentencing. An act regarding deferred disposition. This allows now for Class B, as in boy, drug crimes are eligible for deferred disposition, in addition to the current eligibility for Class C, Class C, or Class E crimes. And again, as we go through this, note that there is a reference to the actual statute that's either been amended or enacted, or in some cases repealed. Chapter 315, an act to support survivors of sex trafficking and exploitation. The law amends the crime of prostitution by changing from an affirmative defense to a defense that a person engaged in prostitution because the person was compelled to do so, and adding the defense that a person engaged in prostitution to prevent bodily injury, serious economic hardship, or another threat to the person or another person. And really what this does, it reduces the defendant's burden of establishing the defense and increase the state's burden in terms of disproving a defense, which is to a standard of beyond a reasonable doubt. Once the defense is sufficiently raised, then the state has a burden of disproving that defense beyond a reasonable doubt in order to move through a trial and into conviction. Chapter 338, an act to authorize expanded deferred disposition requirements. This law authorizes a court to include in the deferred disposition requirements that the person participate for a specified number of days in a program run by a county sheriff that may involve overnight housing, community service work, and education. It also authorizes participation in public works projects by those subject to a deferred disposition. Moving on to Chapter 360, an act to amend the laws prohibiting teachers, employees, and other officials from engaging in sexual activity with students. It essentially prohibits sexual acts, sexual contact, sexual touching between a student and a substitute teacher who had instructional, supervisory, or disciplinary authority over the student at any time during the 12 months prior to the sexual act, sexual contact, or sexual touching. And again, we have the different parts of 17A and a part of 19A that has resulted in amendments. Chapter 373 is an act to expand the crime of violation of privacy to include observing or photographing images inside a private place. This is amendment to current law, section 511 of the Criminal Code, and it adds to the crime of violation of privacy installing or using outside a private place without the consent of the person or persons entitled to privacy therein, any device for observing or photographing images originating in that place that would not ordinarily be visible outside that place. And that might include, for example, an unmanned aerial vehicle, otherwise known as a drone. Chapter 374, an act regarding the outdoor release or abandonment of balloons. This is actually in Title 17, not 17A. It amends the state's litter control law to clarify that waste materials resulting from the outdoor release of a balloon constitutes litter under that law. It provides that it's a violation of the littering law for a person to intentionally release outdoors a balloon that is inflated or filled with a gas that is lighter than air, except for a balloon carrying scientific instrumentation, a balloon used for meteorological observation by a governmental or scientific organization, or a hot air balloon that is recovered after launching. It applies a graduated civil penalty dependent on the number of balloons for the illegal intentional release of balloons. Chapter 388 is an act to amend the child endangerment laws to include certain unauthorized access to a loaded firearm. This enacts a new statute in the Criminal Code under Section 554. It also amends a part of the current 554. It creates a Class D crime if acting with criminal negligence, a person stores or leaves on premises that are under the person's control a loaded firearm in a manner that allows a child under 16 to gain access to the loaded firearm without the permission of the parent, foster parent, or guardian. And the child, in fact, gains access to the loaded firearm and uses the loaded firearm in a reckless or threatening manner, or uses the loaded firearm during the commission of a crime, or discharges the loaded firearm. The law does provide a number of affirmative defenses to prosecution. Moving on to page 5, chapter 266, an act regarding unauthorized possession of a firearm in a correctional facility or jail. Again, we don't have to go all over it. It's pretty self-evident. It's a Class D crime to possess a firearm in a correctional facility or jail. This enacts a new section of the Criminal Code, section 1059. As you can see, it exempts law enforcement or corrections engaged in the performance of public duty. It exempts an employee of a courier or security service in the course and scope of employment, or a person who has stored a firearm out of sight in a locked motor vehicle that is on the premises of a correctional facility or jail. And the fact that a person holds a valid permit to carry a concealed weapon is not a defense to prosecution. Chapter 434, an act to promote public health by eliminating criminal penalties for possession of hypodermic apparatuses. You can see all the different parts of the criminal code, DHHS statutes in 22, and licensing statutes in Title 32. The law essentially amends the provisions regarding hypodermic apparatuses. It allows a person to possess a residual amount of a scheduled drug that is contained in one or more hypodermic apparatuses without committing the crime of unlawful possession of a scheduled drug. It repeals the law governing the crimes of trafficking in or furnishing hypodermic apparatuses and the law governing the crime of illegal possession of hypodermic apparatus. It removes from the definition of drug paraphernalia under section 1111-A of the Criminal Code items used for testing, analyzing, injecting, ingesting, inhaling, or otherwise introducing into the human body scheduled drugs. And it removes similar provisions in the food and drug safety provisions of the Maine Revised Statutes and the Maine Pharmacy Act. So essentially, it decriminalizes the possession of hypodermic apparatuses. Chapter 447, an act to improve investigation of child sexual abuse. And again, we're looking primarily at the criminal code. It provides that a person who poses as a minor is deemed a minor for purposes of a sex crime that has an element or aggravating factor of the crime that the victim or person other than the actor is a minor. It also adds a conduct punishable under the crime of patronizing prostitution of a minor that the person committing the crime believes that the person whose prostitution is sought is a minor, and it makes the new crime a Class C crime. And it changes the existing crime of patronizing prostitution of a person who has not, in fact, attained 18 years of age from a Class D to a Class C crime. Moving on to page 6, an act to create the crime of aggravated sex trafficking of a person 14 years of age or younger. Again, we're affecting sections of the criminal code. Enacting a new section under 852, amending a current section under 852, and repealing a third section under 852. And essentially, this change in law provides that aggravated sex trafficking is a Class B, as in boy, crime, except it's a Class A crime if the person being trafficked is 14 years of age or younger. And note the difference between this and other sex crimes where the different offense levels are often based on the victim being under 14. So this is 14 years of age or under, as opposed to just being under 14. So moving on to a category of drugs. I'm going to skip over that chapter 94. That's kind of obvious. Chapter 396, an act to amend certain provisions of Maine drug laws. And this gets a little complicated, but it essentially alters the treatment of cocaine base, heroin, and fentanyl powder in the drug trafficking statutes. As for cocaine base, it removes any distinctions between cocaine powder and cocaine base or crack, setting the same quantity thresholds for the permissible inference of trafficking, the offense of aggravated trafficking, and the offense of aggravated furnishing. As for the heroin and fentanyl powder, it removes the possession of threshold amounts of those substances from the definition of trafficking and furnishing, eliminating the previous per se violations based on quantity alone. It replaces those per se violations with permissible inferences similar to other controlled substances. The permissible inference of trafficking is set at 4 grams of either heroin or fentanyl powder, and the permissible inference of furnishing is set at 2 grams of either heroin or fentanyl powder. And then we have Chapter 292, which became effective on June 21 of this year, an act to establish the Accidental Drug Overdose Death Review Panel, which sort of follows the model of several other death review panels that we have in statute, including the Deadly Force Review Panel, the Domestic Violence Death Review Panel, and some others. And that's explained out there, and it acts a new section of Title V. On to another category of law enforcement and court procedures. An act to require annual reporting by the Maine Information and Analysis Center, MIAC, shall report annually in writing by April 1st, beginning next year, to the Legislature's Criminal Justice and Public Safety Committee regarding the performance of MIAC. And it goes on to explain what must be included in that report. And this enacts a new chapter of Title 25 of the Maine Revised Statutes, and was a bill passed in lieu of, or in place of, another bill that would have eliminated MIAC. Chapter 267, and then Chapter 342, we have 2 LDs that were passed. One is entitled an act to curtail no-knock warrants. The other is an act concerning the unannounced execution of search warrants. Again, no-knock warrants. In the first one, the Chapter 267 defines no-knock warrant as a warrant that authorizes execution of the warrant without first announcing the authority for the execution of the warrant and the purpose of the warrant. And it provides that any warrant that is executed without waiting at least 20 seconds after the announcement of authority and purpose before making entry is a no-knock warrant. And the law prohibits the use of no-knock warrants except in the event of imminent risk of death or bodily injury to persons, and when a recognized exception to the warrant requirements, such as exigent circumstances, allows unannounced entry. And it requires an officer executing such a warrant to wear an official uniform, and if provided by the officer's law enforcement agency, a body-worn camera worn in accordance with agency policies. The law limits the use of stun grenade, stun distraction, or other similar devices during the execution of a no-knock warrant to only officers trained in the use of such a device during the execution of the warrant. And again, that enacts a new section in Title 15. Somewhat related to that is Chapter 342, which adds to the list of mandatory law enforcement policies the requirements to have a written policy on the unannounced execution of search warrants, that is no-knock warrants, that incorporates at a minimum the policy standards promulgated by the Board of Trustees of the Maine Criminal Justice Academy. So the Board of Trustees at the Academy will be developing minimum standards for that mandated policy, which we can expect would include at a minimum those provisions of Chapter 267 and obviously other provisions. Chapter 381 is another new statute that, or amended statute that requires the Board of Trustees at the Academy to adopt minimum policy standards regarding the recording and preservation of witness interviews conducted by law enforcement officers in murder investigations and Class A, Class B, and Class C crime investigations. And agencies will be required to adopt policies that incorporate at a minimum the promulgated standards of the board And the statute actually says that the policy may not require the recording of all witness interviews, but must factor in the feasibility of recording individual interviews, taking into account the circumstances of the witness, the time and place of the interview, and the crime, as well as the capability of the agency to record the interview. And as you know, present law requires a recording of suspect interviews in murder investigations, Class A, B, and C crime investigations. And there's a reference to the current law there. Again, the Board of Trustees is already working on developing those minimum standards for that policy. And from what I know, this new requirement will simply be added to the current policy that talks about suspect interviews. The board will add to that the standards for witness interviews. Chapter 384, an act to restrict the collection of surveillance video information and data regarding lawful firearm purchases. Enacts a new section of Title 25, and it prohibits the state police from collecting in its records any surveillance video information or data concerning lawful firearm purchases obtained by the Maine Information and Analysis Center, except as needed for purposes of investigating suspected criminal activity or terrorism, administering civil, criminal, or juvenile justice, or protecting a person's health and welfare pursuant to laws governing involuntary hospitalization. Chapter 393 is a brand new law that requires the use of homelessness crisis protocols by law enforcement agencies. And the law directs the Attorney General to adopt a model protocol by January 1st of next year, and directs law enforcement agencies to adopt protocols by March 1st of next year that may but are not required to conform to the model protocol adopted by the Attorney General. The law requires a protocol that includes access and referral to crisis services, mental health and substance abuse disorder professionals, emergency and transitional housing, and case management services for the homeless. And a law enforcement officer who responds to or encounters a situation involving a listed offense is required to inquire whether the person committing the offense is homeless, and if so, the officer is required to respond to the situation in accordance with the protocol. And the listed offenses are criminal trespass in violation of Section 402, subsection 1 of current law, disorderly conduct in violation of Section 501-A, indecent conduct in violation of Section 854 that is based on urinating in public, possession of a scheduled drug in violation of Chapter 45 that is based on using the scheduled drug, and public drinking in violation of Title 17, Section 2003A, subsection 2. The requirement to respond in accordance with the protocol does not constitute the exclusive means of dealing with a listed offense situation. So it may very well be that an officer ends up citing an individual for any one of these violations, but the default position is to refer to crisis services, mental health, substance abuse disorder professionals, and so forth. And the Attorney General's office right now is working with some law enforcement agencies to establish that protocol and have it in place by the January 1st date that will allow agencies time to adopt their own policies by March 1st. A law that became effective on October 1st, and I should have mentioned in the beginning that most all these laws took effect on October 18th, unless otherwise noted. This is one that took effect on October 1st, and it was an act to increase privacy and security by regulating the use of facial surveillance systems by departments, public employees, and public officials. And essentially, it sets up a structure for requests from state, county, and municipal government agencies and other officials for facial surveillance searches and allowed uses of the results of facial surveillance searches, and specifies the manner in which requests for searches must be made to the Bureau of Motor Vehicles and the state police. And you can read on there, but essentially it does set up a structure for making those requests and enacts a new part of Title 25. Chapter 395 probably applies more to prosecutors, but it facilitates children's testimony in certain sex crimes and allows testimony essentially to be videotaped. Chapter 397, an act to amend the bail code. We can provide some final explanations if you want. We have some guidelines from the court on what this amendment to the bail code means. But again, it's primarily of interest to obviously bail commissioners, the courts, and prosecutors. And as you can see, it's explained out there in some detail, but we do have additional detailed information if that's required or needed. Chapter 454 is that's on page 10, where we are now. It's an act to strengthen protections against civil asset forfeiture. And this law essentially does away with civil asset forfeiture. It requires that for property to be forfeited under the criminal forfeiture laws, the owner of the property must be convicted of a crime in which the property was involved, and it prohibits a law enforcement agency or other entity from entering into an agreement to transfer or refer the property seized to a federal agency unless the seized property includes U.S. currency in excess of $100,000. And this incorporates the intent of the sponsor of this bill, that state law enforcement not necessarily cooperate with federal law enforcement in terms of forfeitures. The law requires that records of the forfeited property be posted by the Department of Public Safety on an accessible website. And it goes on to explain when a conviction is not required for a forfeiture, but in a nutshell, it essentially does away with the civil asset forfeiture. On to page 11, an act to implement law enforcement data collection to eliminate profiling. This was LD 132, which became law, Public Law Chapter 460. And it says that beginning on July 1, 2023, a law enforcement agency must record and retain the following information regarding traffic infractions occurring in the state. And it lists out 5 different categories of information that the agency must collect. And obviously an officer involved in these stops will be the initial collector of the information. And that's the number of persons stopped for traffic infractions, the characteristics of race, color, ethnicity, gender, age of each person stopped, with the identification of such characteristics based on the observation and perception of the law enforcement officer, the nature of each alleged traffic infraction that resulted in a stop, whether a warning or citation was issued, an arrest was made, or a search was conducted as a result of each stop or traffic infraction, and any additional information the law enforcement agency determines appropriate. And this information, again, beginning in July of 2023, must be reported to the Attorney General's office pursuant to rules adopted by the Attorney General. And obviously, this is a big lift. It creates a whole new chapter of law in Title V. It's a initiative that the Attorney General's office is working on now with law enforcement agencies, potentially using the e-citation system as a way of collecting this information, but also looking at other systems that may be there in terms of records management systems and that sort of thing. So there's a lot more coming out on this, but that is essentially the requirement that the legislature has put upon law enforcement. Chapter 480, again, this is one that is more prevalent for prosecutors. It's an act to prohibit the constitutional rights or to protect the constitutional rights of indigent defendants. And it prohibits a prosecutor from speaking with an unrepresented defendant until the defendant has been apprised of the right to an attorney, has had an arraignment or first appearance in court, during which certain required notices are provided, and the defendant has executed a written waiver of the right to counsel in each prosecution. And then it goes on to give some exceptions to that. But again, that's a requirement of prosecutors from October 18th out, and not necessarily in law enforcement that much. Break.